Privity. This podcast focuses on the concept of privity of contract. Privity is one of the odd, perhaps archaic, legalistic terms. What it means is very simple, that, as a general principle, only those people who are parties to a contract have obligations or benefits under that contract. That only parties to a contract can sue or be sued for contractual performance. Of course, you might be able to sue somebody on another non-contractual basis, such as under the law of tort, but the general rule is that unless you are a party to a contract, you can neither sue nor be sued under the terms of that contract. I'm not going to dwell on the history of privity, but I do think it demands the briefest of looks. Most commentators consider that the doctrine of privity can be traced back to the case of 1861 of Tweddle and Atkinson, although from the language of the judgment of the case, it would seem to me that the court merely regarded the decision as confirming the existing state of the law, rather than creating anything new. 3 judges ruled in the case, with Justice Whiteman holding that some of the old decisions appear to support the proposition that a stranger to the consideration of a contract may maintain an action upon it if he stands in such a near relationship to the party from whom the consideration proceeds that he may be considered a party to the consideration. But there is no modern case in which the proposition has been supported. On the contrary, it is now established that no stranger to the consideration can take advantage of a contract, although made for his benefit. The language, as you can tell, is the language of consideration, that to enforce a bargain, a person must have shown consideration, even though the deal conferred a benefit on that person. In the early 20th century, the judgment of Viscount Haldane, Lord Chancellor, in the House of Lords, in the case of Dunlop Pneumatic Tyre and Selfridge, separates the doctrines of privity and consideration further. Viscount Haldane said, "My lords, in the law of England, certain principles are fundamental. One is that only a person who is a party to a contract can sue on it. Our law knows nothing of actionable third-party rights arising by way of contract. Such a right may be conferred by way of property, as, for example, under a trust, but it cannot be conferred on a stranger to a contract as a right to enforce the contract in personam." This principle was reinforced in the case of Beswick and Beswick, in which, despite what would seem to be a desire on the part of the court to find a solution which they felt was equitable in the circumstances, they shied away from overruling the core principle that someone who is not a party to a contract cannot sue for a benefit due to them under it. Enough theory for now, let's talk about privity in practice. Take a practical example. I contract with your best friend, entering into a simple agreement that says that you will come and sing at my party. The party comes around, and you do not come and sing. I may be able to sue your best friend for failing to deliver his or her obligations under the contract, but I cannot come to you and say, I entered into a contract with your friend, and you are bound by it. It makes perfect sense, but that is the law of privity in action. Let's take another example, though. I contract again with your best friend, with an agreement that if your best friend mows my lawn, I will pay both them and you £10 each. Your best friend mows my lawn, and I pay them their £10. But what about your £10? Can you sue me for failure to pay? Under the traditional doctrine of privity, although a benefit accrues to you under the contract, since you are not a party to that contract, you have no standing to sue. You are not a party. And so, while you might be expecting £10, the doctrine of privity prevents you from suing me for breach of contract. Your friend may be able to sue me for breach of contract, although, as we will discuss later in this series of podcasts, there's probably a question as to whether your friend has suffered any loss in respect to the £10 due to you. But you cannot sue. And if you think back to the podcast on promissory estoppel, even if you had relied on my promise to pay you £10, you are not a party to the contract. There is no legal relationship between me and you. and you have offered no consideration at all in exchange for your £10. You have no basis in the law of contract to sue me, no right of action. And promissory estoppel acts as a shield, not a sword. It does not create a legal right of action. You can't use promissory estoppel to enforce performance of what you would probably argue is my duty. This can seem a little harsh, since although you are not a party to the contract, and although you have given no consideration at all for the benefit flowing to you, there is clearly an intention on my part to give you £10, and over the years this has been one of the major criticisms of the law of privity. In 1996, the Law Commission recommended a limited degree of reform to the doctrine of privacy in its report number 242, which it published along with a draft bill amending the law in this area. That draft bill ultimately became the legislation which still governs this area today, the Contracts Right of Third Parties Act, 1999. Do take a look at this piece of legislation. It's not particularly long and may make a considerable difference either to your rights, if you're a beneficiary, or to your scope of exposure if a third party gets a benefit by virtue of a contractual duty which you owe. It doesn't remove the doctrine of privity, but it does offer a substantial exception to it. Section 1 of the Act contains the exception. It provides that, subject to the provisions of the Act, a party who is not a party to a contract, a third party, may in his own right enforce a term of the contract if the contract expressly provides that he may, or the terms purport to confer a benefit on him, unless, on a proper construction of the contract, it appears that the parties did not intend the term to be enforceable by a third party. So, if a contract expressly provides for third-party enforcement, or seems to do so, and if read correctly, the contract does not say that the parties intended otherwise, this third party has a right to enforce the term. It's not absolute, there are some limitations in the Act, but it is a pretty wide-reaching rule. How can you tell which third parties have this right? Section 1(3) of the Act provides that the third party must be expressly identified in the contract by name, as a member of a class, or as answering a particular description. But they need not be in existence when the contract is entered into. I could therefore describe the beneficiary of a contract as any children I may have, even if they are currently unborn. It does not require that the third party is named, which in practice means that you are likely to want to take extra care in ensuring that any description based on a class is appropriately constrained to avoid finding that you have all number of people capable of enforcing terms of the contract despite passing no consideration to you. There are protections within the Act to prevent the parties to a contract from simply agreeing to vary the terms of the contract and exclude or remove third-party rights. These protections are provided within Section 2 of the Act and provide that where either the third party has communicated assent to the beneficial term, or the person making the promise knows that a third party has relied on the term, or can reasonably be expected to have foreseen that the third party would rely on the term, and in fact the third party has relied on it, variation to exclude the rights of that third party is not permitted. The protection is not absolute, and where there is an express term within the contract under which the parties to the contract may, by agreement, rescind or vary the contract without the consent of the third party, this term overrides the general protection. So consider whether you would want to include a clause of this nature in the contract or not. In terms of practical implications, the Contracts Rights of Third Parties Act 1999 may assist if you, as a beneficiary under a contract, want a right to be able to take action to enforce that benefit. But it does not permit burdens, obligations, to be placed on non-parties or for you to sue a non-party. To achieve this, you would need to make the non-party a party to the contract, although this requires that consideration flows from you to this new party as well as in the other direction. If you can live without a direct right of action against the third party, you could look to place an obligation on the counterparty to fully achieve an outcome, permitting it to use the third party if it so wishes, but without any shift in responsibility. We could consider this a flow down of obligations. By way of example, let us assume that A and B are entering into a contract and that B cannot perform all its duties alone. It needs to engage other parties to do part of the work. For example, A is a homeowner and B is a builder, but B requires C to do some plumbing work. The contract between A and B may simply oblige B to complete the house to the required specification, including the plumbing work. If B needs to engage or subcontract C to do the plumbing work, that's for B to worry about. B is responsible for C's performance or non-performance, as B is fully responsible for the overall building work. In such a case, A has no right of action against C is not a party to the contract, but can sue B in the case of C's failure. B may be able to sue C, and will probably want to ensure that it has backed off its obligations to C to protect it against non-performance, but A cannot sue C. In summary, the traditional doctrine of privity holds that only those who are parties to a contract can sue or be sued under that contract. Although there are certain similarities and links to the rules of consideration, privity is a separate, standalone doctrine. The Contracts Rights of Third Parties Act 1999 goes some way towards mitigating what can be seen as the harshness of this doctrine, although even then it is possible for an express contract clause to permit parties to a contract to agree to modify or vary a contract to exclude third-party rights, so even that protection is not absolute. As a general principle and a practical rule, if you want to be able to sue somebody directly for breach of contract, or you wish to impose obligations on someone under a contract, make sure that they are party to the contract.